Welcome, everyone, to this Just Majority Roundtable on Loper Bright Enterprises and Relentless, Inc. I'm Beth Binchik, the Director of Policy and Program for Economic Justice at the American Constitution Society. First, I want to thank Demand Justice for helping us organize this timely and educational discussion. Anti-regulatory forces have been waging an attack on the administrative state for years. Yesterday, the Supreme Court heard oral arguments in two cases that challenge a pillar of administrative law, Chevron doctrine. I'm thankful to have an incredible panel here to help us understand how cases about the Atlantic herring fishery could fundamentally alter the way that our federal government works. First, we have Paul Bland, Executive Director of Public Justice. Next up is Persis Yu, Deputy Executive Director and Managing Counsel of both the Student Borrower Protection Center and Protect Borrowers Action. Last but not least is Doug Lindner, Senior Director of Judiciary and Democracy at the League of Conservation Voters. Welcome, everyone. It's great to have you. Persis, to get us started, what is the administrative state and why should we care about it?
This is an excellent question, and I think really helpful for such a wonky court case that most people have never heard of and aren't paying attention to. So kind of as I explained to my team this morning, as I was trying to recap what happened yesterday, was the administrative state is really just like how our federal government works for the people, right? Like, what are the day-to-day functions that allow the government to do the work of protecting everyday Americans? I think about, the work that Doug does and like protecting, the environment, making sure we have clean air to breathe and clean water to drink. Kind of in the work that we do, we're very concerned about financial products and making sure that they are, that there are robust consumer protections available to borrowers and consumers. In the education space, we're looking at regulating schools, coming up with federal student loan policies, including, importantly, big topic of debt relief for millions of student loan borrowers, but also like thinking about Title IX and civil rights protections and it really is just like, how does our federal government function for every single day, everyday people?
One of the most frequently cited principles in administrative law comes from a 1984 case, Chevron USA versus Natural Resources Defense Council. Doug, could you explain what the so-called Chevron doctrine is?
Yes, thank you, Beth, and thank you to Demand Justice for hosting, and to Persis and Paul, and thank you to all of you for coming. The legal issue in yesterday's cases is whether the court will overturn or change the most important precedent you've never heard of, Chevron v. NRDC. And because Chevron is so important, this is an opportunity for the MAGA justices to give themselves to grab even more power over every area of public policy. The Chevron doctrine says that if there's an ambiguity in a federal statute administered by an expert agency, the way the EPA administers the Clean Air Act, for example, courts are supposed to defer to the agency's reasonable interpretation of the law. And this is massive. Chevron has been cited in court decisions more than 18,000 times, more than Brown v. Board of Education, more than Roe v. Wade, more than any other case you can think of. The Chevron doctrine is fundamental to the ability of every public interest agency across the federal government to protect the people from powerful special interests, the same far-right special interests paying the lawyers who brought the case and who have substantially bought the court. The same special interests using the 6-3 MAGA supermajority to roll back our rights to clean air and clean water, our right to abortion, our right to vote, our right to be safe from gun violence, our rights as workers, as patients, as consumers, the rights of immigrants, of racial and religious minorities, of LGBT people, of students, and of every human being who wants to pass on a sustainable climate to the next generation. The same special interests, of course, are flooding our politics with corporate cash, thanks to these same right-wing justices who decided in Citizens United to let them, who uphold partisan and racist gerrymanders, who have struck repeatedly at the heart of the Voting Rights Act, and who constantly take up new opportunities to grab power from the people and our democracy so they can shift that power to big business, to far-right extremists, and to the billionaires who the justices just happen to make friends with when they ascend to lifetime seats on the most powerful court in the world. What an incredible coincidence. Seriously, it's not credible. Chevron was not always a partisan issue. Clarence Thomas used to support the Chevron doctrine, and he rarely changes his mind on anything. But something has changed. And what's changed is the new 6-3 MAGA supermajority built by Donald Trump, who lost the popular vote, and senators who represented less than half the country. Between the 6-3 supermajority, life tenure, and strategic retirements, the far right is expected to keep control of our nation's highest court for generations to come. And that means more power for the Supreme Court is more power for those same right-wing special interests. They know it, we know it, and the justices themselves know it. That is why they're grabbing all this power. That is why the oil-backed Koch political network is paying the lawyers who brought this case. That's why Clarence Thomas, who's been speaking at Koch political fundraisers, has not recused himself. In sum, overturning Chevron is not just about taking power from the scientists and experts at public interest agencies like the EPA. It's about taking power from the people and our elected leaders. It's about our democracy. And once again, the MAGA justices seem ready to roll it back.
So Paul, the Chevron doctrine feels pretty wonky. What are the benefits of that doctrine? What does it really do and function?
So first, so grateful to be included in this terrific program and very grateful to have been invited. So the administrative state is really important in America. It literally saves lives. We have airbags and seatbelts because of the administrative state. We have significantly limited pollution, acid rain, climate causing greenhouse gases. Drugs are safer dramatically than they were prior to having the FDA. When you had lead paint in gas when you had lead in gas and paint, you had a ton of Americans who were getting sick and dying from these things. And the administrative state has been able to deal with it by being experts. You have people at these agencies are overwhelmingly scientists, they're doctors, they are people who look at data, who crunch the data, and who know. So if you replace Chevron, which says that the administrative agencies that are expert will make decisions that are reasonable, as long as they're making reasonable decisions that you defer to them, with first of all, with Congress making decisions, that's going to be a disaster. I mean, how many members of Congress are at all scientifically alert as to which drugs are dangerous or as to which pollutants are dangerous? So they would just be entirely dependent on lobbyists telling them what to do and campaign contributions. Their ability to make these sorts of decisions is just nil. I mean, and I totally agree with Persis bringing up financial products here. In the run-up to the 2008 financial crisis, you had one agency, the Commodity Futures Trading Corporation, that realized that a bunch of financial institutions were engaged in incredibly dangerous, basically speculative investments, and that this was becoming a huge part of our financial system in a way that was, that people were doing things that were so speculative, it would be like betting on the NBA against the point spread. It was like really something where they were just reaching. And so Congress got a whole bunch of campaign contributions and came in and literally cut the CFTC's budget in half. That's sort of congressional interference in the regulatory system. By and large, the Congress hasn't done that. So that there have been, there are a bunch of regulatory systems that operate pretty well. Taking that away from them is dangerous. Then if you start having individual judges making national policy, we've gotten some more and more extreme judges. So this Amarillo federal court down in Texas, somebody can file a case and they know which judge they're going to get, which is not true. So if you filed a case in Baltimore in federal court, there's like 12 different judges you might get. If you filed a case in New York or San Francisco, there's a whole bunch of judges. You file a case in the Amarillo division in a particular court, and you're going to get a single guy. And so then you start getting somebody like a judge whose entire history prior to becoming on the bench was that they're an anti-choice activist. And is that really somebody who it makes sense to say they're going to make decisions nationwide as to whether medication abortions are actually safe or not? And so you've got medications that are, safer than Tylenol, but then you've got a zealot who's just, entering nationwide injunctions left and right and deciding these cases. That's sort of what's going to happen if we start taking away power from regulatory agencies and giving it to a single federal judge in, one part of the country. It's a huge power grab and really disastrous. So Chevron's been important, and losing it will be a huge loss.
These cases involve an interpretation of the Magnuson-Stevens Act. Under the Act, those engaged in certain fishing activities may be required to carry observers on board their vessels. These observers collect data that is critical to the Act's purpose of conserving and managing fishery resources. The National Marine Fisheries Services issued regulations that would require the vessel's owner to pay for the cost of the monitoring services in certain circumstances. The petitioners aren't challenging the requirement that they carry the monitors. Rather, they're arguing that they cannot be required to pay for those monitors. I think it's now been more than 5 years since the Supreme Court relied on Chevron to decide a case. Versus, could it decide these cases based on the narrower question without wading into the challenge to Chevron?
I mean, I think certainly they could. I think the cases here are about, whether or not Congress, mandated whether or not it's reasonable to interpret that Congress is mandating these the fee for these monitors. I think certainly the court could wade into the question about whether or not the statute even is ambiguous here, right? Thinking about the 2 steps that Doug laid out before, right? Like, we could just decide that we don't need to overturn Chevron because the statute is actually just clear that agencies can charge this amount of money, or that the court could just agree that it was a reasonable interpretation and we don't need to get into the question about deference. So I think that is certainly a thing that could happen. I don't know. I didn't hear a lot about fisheries yesterday or about the actual, Magnuson-Stevens Act itself. Like, that really wasn't the crux of what was being discussed at the court. And so I think at the end of the day, this isn't about, fees for observing boats on fisheries. That, like, this is really the question that the court wanted to come to here.
In October, the Supreme Court granted cert in Relentless. Doug, why do you think the court decided to hear Relentless with Loper Bright?
Because it's a better name. No, I'm kidding. They didn't explicitly give a reason, but I think the consensus from court observers that the reason they did this is that Justice Ketanji Brown Jackson is recused from Loper Bright for technical reasons related to her brief service on the DC Circuit not that long ago when the case was making its way there. She can participate in Relentless, and it is good for all kinds of non-ideological reasons for the court to be making big decisions in cases in which all 9 justices can participate. That said, although I personally generally think that any decision will be better made if Justice Jackson is involved, and not just judicial decisions, but in general, in your life, ask her for advice. She's a great person. But beyond that, it's worth keeping in mind that there is a 6-3 right-wing majority on the court. And that means not only can the right-wing justices get their way in spite of having all 3 of the liberal justices participate, they can actually get their way even if not all 6 of the conservative justices agree with each other. That's what happened in the Dobbs case when they overturned Roe v. Wade. Chief Justice Roberts didn't want to do that, but they still did it because there were 5 of the 6 who wanted to. It's also what happened in last year's big clean water case, Sackett v. EPA, in which Justice Kavanaugh did not want to go quite as far as the other right-wing justices, but they still had the votes. Chief Justice Roberts is a savvy political operator who likes to have his cake and eat it too. He wants to be perceived as even-handed and an institutionalist, and also wants hard right-wing policy outcomes. And allowing Justice Jackson to participate in this case by making it focus on Relentless rather than just Loper Bright is one that is the right decision for the court, but it's also one that, helpful to the side of those who want to support big business, is relatively unlikely to affect the outcome given the ideological imbalance of the court right now.
The petitioners assert that Chevron violates Article 3 of the Constitution because it interferes with judges' duty to say what the law is. And they make a similar argument that Chevron violates Section 706 of the Administrative Procedure Act, which says that the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. Paul, how would you respond to these arguments that judges abdicate their duties when they apply the Chevron doctrine?
So the idea that a court can't decide a case if there is a presumption in one direction in the case is flatly bizarre. I mean, so for example, the courts regularly apply presumptions that have them acting with some humility in a wide range of places. So for example, if there's a jury trial and the jury reaches certain findings of fact, appellate courts and federal district courts are not supposed to disturb the jury's fact finding except for extreme outlier cases. They're supposed to defer to this jury. Does that mean that it violates the Constitution violates Article 3 to have juries be given some deference. It's a palpably off the wall argument. Similarly, there are cases that are decided in arbitration, for example, that where there's a very limited scope of review. Does that violate Article 3? No, that's something that courts are extremely familiar with. There is also this idea that it violates the Administrative Procedures Act. There was deference to administrative agencies before the Administrative Procedure Act passed. Congress said when it adopted Section 706 that it was adopting the previous existing case law, which did allow for significant deference to agencies. So I think that this is the pressure to get rid of Chevron deference really comes from policy arguments. And I think that if you looked at the oral argument yesterday, again and again, some of the justices who were showing the most interest in getting rid of Chevron, they didn't even really focus on the text of the statute, the text of the constitutional provision. They really focused on how they think this is a bad idea because there's too much regulation. There's a strong deregulatory impulse. There are a lot of people on the court who have sort of a relentless urge towards, siding with the overdog. And that was where, it was driven much more by policy than it was by legal arguments here, in my view.
The petitioners also argue that applying Chevron violates due process because the doctrine calls for judges to defer to agencies in certain circumstances. They argue that this gives an unfair advantage to the federal government in its own case. Persis, what do you think about this argument?
So I similarly find this argument to be like oddly incoherent. I think I was discussing this with a colleague and he said, due process isn't a magic phrase that means that governments just can't do things, right? So we still have process to make sure that, what the agency did was allowed. Right, like Chevron provides said process, right? Like we have to make, like you have the first step of the analysis is like, is it ambiguous what Congress wanted to do, right? Like you have to engage in that process. We also, again, as Paul was mentioning, have the Administrative Procedures Act. So there still is process to make sure that what the agency is doing is right and has basis. But I think, I think more fundamentally, like this argument isn't coherent for me because what the court is being asked to do here is whether an agency's actions are meeting with congressional intent. And so Chevron has been the rule of law for roughly 40 years. And so Congress has been writing rules for the last 40 years with the understanding that Chevron is in place. The work that we do is often more with Congress than actually with the courts. And as we're talking to Congress, like there is a broad understanding that like there are agencies who know things. You don't need to have it all figured out. You can just, you can write with the intent of what we're trying to go. Where are we trying to go here? And understand that there's going to be an agency who will be able to drill down on it, who will be able to shift. I mean, one of the things that came up yesterday is this whole notion that like the rules change. And it's, yes, rules do change both because there are elections where people say that they don't like the direction of what the rules are. And because we get more information with time as well. And so, giving agencies this discretion allows them to use information. And that is entirely within like what Congress understands as its toolbox, as it's legislating. And so I think, it seems a little bit of an off the wall argument, in my opinion, to say that like this is somehow not meeting with Congress's intent when Congress knows that this is part of the way that its rules will be used.
Critics of Chevron have also said that the doctrine is unworkable in practice, with different judges having different thresholds for finding statutory ambiguity. Doug, how would you respond to that?
Chevron has been cited and applied by courts more than almost any other precedent in American history. First-year law students learn about it. It's on the bar exam. Courts know how to do this. They have not just a mountain of precedent to draw on, but a whole Rocky Mountain National Park of precedent. And different judges potentially having different thresholds for finding statutory ambiguity is a concern that pales in comparison to the variation and discretion we'd have in the courts without the Chevron doctrine. I'll give a hypothetical. Let's assume for the sake of argument that there's a law. We'll call it the Do Something About Pollution Act of 2024, and it's administered by the EPA. Now, assume the Do Something About Pollution Act is clearly ambiguous. Any judge would say it is. That ambiguity means there are judgment calls to be made about what the policy will mean in practice. With Chevron, those judgment calls are largely left to the scientists and experts at the EPA, and as long as their interpretation of the Do Something About Pollution Act is reasonable, courts are supposed to let the scientists, experts, and presidential appointees at the agency figure out what's best based on the text of the law, as well as their understanding of the science, the logistics, the government's ability to execute on specific deliverables, cost-benefit analysis, and the preferences of democratically elected leaders like the president, the Congress, potentially governors or mayors in some situations, as well as from interested parties, and from regular people through formal notice and comment process, which anyone can participate in. But without Chevron, the judges would be empowered to second guess all of that. And judges are not qualified to analyze all those policy factors I went through. And as a lawyer, I promise you, they are not qualified to consider the science. If a law is so ambiguous that a judge would formally call it ambiguous, that is them telling you the skill set of judges and lawyers is not well suited to deciding what should happen. So if the judges are making those decisions and they're not qualified to analyze all the considerations an agency would, what's left? The answer is the judge's ideology, their policy preferences. And in the case of a Supreme Court with absurdly low ethical standards, it can even come down to the personal financial interests of the justices and their friends, benefactors, and political allies. As Americans, we tend to think about our core governmental institutions in terms of separation of powers and checks and balances. We have executive, legislative, and judicial branches, federal, state, and local government. All this division of power intended to ensure that no one institution, no one faction ever gets enough power to usurp the prerogatives of the voters, of the people. But that balance is fundamentally broken right now, because unless Congress expands and rebalances the Supreme Court, we're looking at permanent Republican control of a court that's basically as powerful as it wants to be if the justices are willing to act in bad faith, which they are. So there's a perverse incentive for the MAGA justices to grab as much power as they can for the Supreme Court itself, knowing that they and their political allies can count on that institution to do what right-wing politicians, billionaires, and special interests want, not just for 2 years or 4 years, but for 50 years or more. The Supreme Court is the least accountable institution in our entire constitutional structure. Its members are not elected, they serve for life, so they're not accountable to anyone, and their decisions are final. They are experts in law, but not in anything else. And the more policymaking power they take for themselves, from scientists and experts, from elected leaders, and from the people, the more we have to question, how much do we trust these people? How much power do we want them to have? And what are we going to do about it?
One of the things that the petitioners suggested was that courts should find the best interpretation of a statute. Doug, I just want to ask, would that really prove a more workable standard?
For judges to find the best interpretation of the statute?
Yeah, if they can't agree on ambiguity, maybe all the judges will agree on what is, the best interpretation of these statutes.
Certainly not, because the fact that they think it's ambiguous tells you their skill set is not suited to deciding what is the best interpretation. And so once again, it just comes down to their ideology. And I think, at that point, really, when it's a big regulation that's big enough to go all the way up, that ambiguity will come down to what is the ideological makeup of the United States Supreme Court. And I think if we're going to have things where some governmental body is voting on something based on political control, it should be an elected body where there's some accountability to the people.
So we have a question in the chat here that talks about the stare decisis and reliance interests. Says there's some discussion of the oral arguments, the reliance on Chevron doctrine, and the Solicitor General noting that Congress has had this in the background for the last 40 years. Persis, could you just talk about that component of reliance, how that operates in practice?
Yeah, so I think that was a really interesting discussion that came up yesterday during the arguments about stare decisis and what would the practical implications happen, right? Like, we have relied on Chevron for a very long time, both through the process of Congress enacting laws that they have been they have used this in the backdrop. So every statute that has been passed over the last 40 years has kind of this understanding that we have agencies that are going to interpret it. So I think that there's a real fundamental issue here about well, how do we understand Congress's intent if Congress had Chevron as, in its pocket when it was drafting its, its laws. So I think that's a really interesting component, but also all of these cases that have relied on Chevron and what happens to that. And I think, this comes back to kind of the big picture, right? So I think there's like an interesting legal question about like, how would these things be undone, that I think is kind of technical, but I do think that it gets a little bit to what is the main goal here of the folks who've been bringing these cases. And I think what it is to, it is to start bringing up all of these cases and all of these cases in which they have lost, and make it so that all of our federal regulations, all of the things holding big companies accountable are called into question again. We know that, that there's been a very active right-wing approach to challenging all federal regulations through the courts. And I think we're just going to see more and more and more of that happening if Chevron is undone.
As the government points out, justices with a wide variety of jurisprudential views have applied Chevron over the years. The government cites a number of opinions to support this, including opinions offered by Chief Justice Roberts and Justices Thomas, Alito, and Kagan. Paul, what's changed?
It's a great question. I mean, I think Doug put his finger on some of this earlier. The Chevron case itself arose because Neil Gorsuch's mom, when she was EPA administrator, wanted to gut some important environmental regulations, and the NRDC took them to court and said, this is the Clean Air Act and so forth, don't permit this. And the Supreme Court came up with the Chevron doctrine to let the Reagan administration downgrade environmental rules, and that was it was not something that was seen as controversial at the time for a long time. And Justice Scalia really loved the Chevron doctrine and spoke favorably about it a number of times. Around 2008, a couple of big things happened. So one was after Citizens United, you suddenly were able to have money in American politics in a way that had never been before. So the Kochs, before Citizens United, there were these, you could only put a certain amount of money into campaigns. And after Citizens United, the Koch brothers suddenly were actually able to put $1 million into an individual cycle. And it changed American politics radically. So, Senator Sheldon Whitehouse has traced through how prior to Citizens United, you had tons of people in both parties who are willing to support legislation that would deal with climate change. And after Citizens United, pretty soon it became a solely partisan issue where one party was never willing to support anything to do with climate change again. I think something similar was happening to the court. There was a feeling in the conservative circles that President Obama was doing a number of things that they thought were harmful. They were worried about the Affordable Care Act was going to create a new generation of people who were dependent on government benefits. There was this real feeling that they needed the courts to sort of start putting limits on the Obama administration. And all of a sudden, the Federalist Society and a number of groups began writing about this and sort of creating the intellectual backdrop on it. I also think that the court has shifted in more extreme directions than their predecessors. So, Justice Scalia was a very conservative justice, but he would never have signed on to an opinion like Gorsuch did with Justice Thomas in the Sackett case, where basically Gorsuch adopted an approach to the Constitution that would let the court strike down minimum wage laws or child labor laws or almost anything. And so that you've got a couple of members of the court who are taking not just a deregulatory impulse the way John Roberts would have been, 15 years ago to say, well, maybe the government's involved in too many things. Like if you think the government shouldn't be able to have child labor laws, you're really in a pretty extreme place. And that is where the court is headed. And I think there's also, I do think it's true that there's an awareness that the court is going to have a conservative orientation for a long time. And so one thing that's changed is, there was a period where the court was sort of stepping back because they wanted to make sure that, like the Reagan administration could do what it wanted. I think the court now sort of feels like if there's somebody who's a conservative in the White House, that they can do what they want without having to worry about the details of the legal doctrines, because no one knows, no one cares. They can just do what they want. And I think that there's a move to aggregate greater power in themselves because they sort of trust and like themselves more than other actors in the government.
Versus Chevron is a seemingly neutral doctrine. It provides for deference to executive agencies without regard to who controls the executive branch. So why is it under attack and who would benefit from its demise?
Yeah, so I actually think latching on to like the last few words that Paul just said, right? The greater importance in themselves. I think context is so important here. And that this is genuinely a part of a bigger strategy to kind of attack multicultural democracy at its core, right? And so I think, thinking about, yes, like the Supreme Court is like one incredibly important thing that we need to think about. And second, all of the things Doug and Paul have said about that, but also like thinking about the broader strategy of what groups like the Federalist Society have been working towards over the last several decades, right? So we see a lot of focus on who gets appointed to the federal judge on like the district court level, right? So who are all these Fifth Circuit judges that are making these decisions, and who gets to appoint them, and who are they there? And they're there for lifetime appointments, right? I think that's a really critical component to understand, that like this is a lifetime appointment. So who gets to make the decision? Well, these folks who the Federalist Society and folks of that ilk have put into positions of power who can't be taken out, right? Who are not taken out. And the other work that they've done is on the state level, right? Having done a lot of work to gerrymander state legislatures in order to ensure that we have very conservative majority legislatures, not majority in the states necessarily, but people in power in those states. And so what do you have when you eliminate the federal administrative state, right? You have, the decisions that like what Congress has done doesn't apply because you have these federal judges who say that it doesn't. And then you have the states who are very conservative, making determinations about how everyday people in their states live, right? So that's, enacting abortion restrictions, that sort of thing, empowering for-profit colleges, right? And so it really is about like eliminating this administrative state, and then like who holds the power once that's gone. And I think that's the piece that it's important for folks to look at, is who holds that power. It's corporations who like work across states, it's people with money, and it's the states who have been, or the politicians who have been in power in those states as well. So I think that's the important context that people need to keep in mind as they're looking at these things, and wondering why we care about what Commerce does with monitors on fishing boats.
Loper Bright and Relentless are not the only challenges to agency power that the court is considering this term. Paul, how do these challenges to Chevron fit into that broader picture?
So there, I keep wanting to make puns off of the name of one of these parties being Relentless, but there has been a concerted, if not relentless, attack on the administrative state at the Supreme Court for a while. Not all of the cases succeed. So the attack on the Consumer Financial Protection Bureau, where the Fifth Circuit found that it was not properly funded, and under the Constitution, that the Constitution supposedly does not permit Congress to say that an agency could be funded in an indeterminate amount under a cap that's funded by user fees or this sort of thing. That got to the Supreme Court, and it was too radical, too out there, and it seemed very clear from the oral argument that they did not have many supporters for that. So I think it seems very likely the Consumer Financial Protection Bureau will survive. But the people who are attacking the Consumer Financial Protection Bureau, you can really see why the payday lending industry brought that case, and why major banks came in, because they hate the idea that you now have a consumer agency that actually sticks up for consumers after you had all these years of the Office of Comptroller Currency and the Savings and Loan Agency that were totally in the pocket of industry. But there have been a series of these attacks. So the Jarkissi case, where the SEC had a policy, or had a series of regulations where if there was certain fraud by brokers, and so in this case, this guy made a series of totally false statements to investors and ripped them off in a huge way. And so the SEC said, well, this is we have the ability to have this case handled by an administrative law judge. And so if you look at all the different agencies, there's like 10,000 administrative law judges who decide all sorts of issues. The oral argument in the Jarkissi case really looked like they're going to strike down administrative law judges, at least for the SEC. Now, this is going to be a dramatic shift in the law. Prior to this year, literally, if there's a public agency that is enforcing a public statute, it was understood that the agency could bring administrative actions in front of administrative law judges. You didn't have to have a right to a jury trial and so forth. And they're probably going to strike this down and say that the right to jury trial means that stockbrokers engaged in fraud get to go to federal court rather than to an agency. So this, again, I think has a certain element of power grab to it, that you have, 10,000 plus administrative law judges across all these different agencies deciding cases. And what federal judges look like they're about to do is say, no, we're going to decide all of these ourselves, which is a pretty dramatic shift. And there's just one case after another like this. If you look at the Federalist Society's, their agenda for meetings, they have like panel after panel in which different corporate lawyers or sort of right-wing professors are up there coming up with, here's another way that you could gut the administrative state, and you've got, you had the anti-tax activist Grover Norquist used to brag that he wanted to make the federal government small enough that you could drown it in a bathtub. I think that's sort of a notion that lies behind where the Federalist Society is trying to push the law. So if they get rid of, if Jharkhasi comes out and wipes away most administrative law judges, and Chevron means that courts will no longer defer to expert agencies, I think you're going to start seeing the business community, I think, is not going to say, we're satisfied now. We're gonna sit back and rest on our laurels. They're going to be coming up with like 10 more ways to try and gut the administrative state. I think I think they are feeling emboldened and encouraged. And so some of their things that are too clown show, like the CFPB versus Consumer Financial Protection Agency versus Consumer Financial Services Association, some of those things are not going to work, but they're going to keep coming back.
At oral arguments, Justice Jackson raised concerns that taking away Chevron could turn the court into a policymaker. Some ways this seems to echo Justice Kagan's dissent in West Virginia versus EPA, in which he said that the court was substituting its own ideas about policymaking for Congress's. Doug, how do these cases about Chevron and the major questions doctrine fit together, and what do they say about the role of the courts?
Sadly, this Relentless case is far from the first or the only attack by these MAGA justices and their allies on the ability of public interest agencies across every issue area, across the entire federal government, to do the jobs our elected leaders created them for, as Paul was alluding to just now. The major questions doctrine is a concept the right-wing justices fabricated to give themselves the power to veto big regulations that they just don't like. In theory, it's about regulations being too economically or politically significant for agencies to move forward without specific congressional authorization. But this principle, and I use the word principle, I was going to say loosely, but instead I'm going to say I use the word principle ironically, does not come from the Constitution or from the Congress or from the founders. The justices made it up the same year the movie The Lion King came out. And every time they've ever used it, it has been to stop progressive policies, including on student debt relief and climate. So in 2022's West Virginia v. EPA, which is the first time the court ever actually used the phrase major questions doctrine in a decision, they severely limited the EPA's authority to fight climate change under the Clean Air Act. And if the major questions doctrine itself weren't enough to tell you that that case is not on the level, I'll go even further. There was nothing to rule on. One of the few constitutional limitations on the Supreme Court's power is that they're not supposed to rule in the absence of a real case or controversy. That is in the Constitution. But the regulation they ruled on in West Virginia v. EPA was already gone and had been for years. The Obama administration put forth the Clean Power Plan in 2015, and at the time, before the Inflation Reduction Act, at the time, that was the most ambitious climate action of all time, or it would have been if it had ever gone into effect, which it did not, because right-wing justices held it up until President Obama left office. At the same time, Senate Republicans were holding up President Obama's nomination of Merrick Garland to the Supreme Court. Donald Trump repealed the Obama Clean Power Plan, and the Biden administration said they would not bring the same regulation back. But Trump and Senate Republicans had also moved the Supreme Court way further to the right, and so the justices decided to rule in 2022 on the Obama Clean Power Plan that was already gone. As Beth noted, Justice Kagan's dissent in West Virginia v. EPA says that the court is appointing itself as the decision maker on national environmental policy. substituting its judgment for that of Congress and refusing to allow the law to work as Congress instructed. She says the court itself will now decide how much regulation is too much. A year later, in 2023, the MAGA justices decided in Sackett v. EPA to roll back Clean Water Act protections for most of the wetlands in the United States, imperiling clean drinking water for millions of people. And in that case, Justice Kagan quoted herself from her West Virginia dissent, saying once again that the court is taking power from Congress to decide on national environmental policy. Justice Kagan, the most moderate of the 9 justices, then ended with a harrowing point. She said, and I quote, "That is not how I think our government should work. It is not how the Constitution thinks our government should work." So remember, this is not just about environmental policy. These issues, these attacks on the administrative state and on the ability of public interest agencies to do their jobs, this touches every federal agency. It touches every area of public policy, and it touches every single American.
So I want to lift up another question that we have in the chat here. We've got a question I foresaw. What predictions do you all have for the holding? Or what are some of the points you'd like to draw out from what we heard in oral arguments yesterday? Paul, I'll start with you.
I think that after reading the transcript, I will be shocked and really pleased if they don't overturn Chevron. I think that there had been some hope early in the argument that Chief Justice Roberts and Justice Barrett might be looking for a narrower way to decide this, might be looking for a way to just sort of say that fishing boats don't have to pay for the monitors to see if they're being overfished. Instead, later in the argument, I think you started seeing the Chief Justice and Justice Barrett moving more into line and saying that Chevron as a whole had to go. So I think that the particular regulations likely to be struck down, and I think that Chevron deference, I think they're going to overturn the Chevron case, and it certainly seems that way. I hope I'm wrong.
Persis and Doug, do you have anything you'd like to add?
So I mean, I don't like to concede defeat until I actually have to face it. Is a little bit my approach here. Or I guess more positively, like hope springs eternal. But I do think, I think some of the things just to lift up from the oral arguments that I did, Doug mentioned, that debt cancellation and, the environmental protections were struck down the major questions, and that came up yesterday, and I feel like that kind of signaled actually what they really wanted to do here, right? That like to try to get away from this, like the things that they had struck down with the major questions was really like, let's not even let the agencies have a chance to try, right? By getting rid of Chevron. And I think they really did signal like the bigger picture intent here during the arguments when they raised that. So I think that's just the one thing that kind of did stick with me. I don't think that Paul's wrong. I don't like to concede defeat yet.
Fair enough.
I tend to share Paul's pessimism about the outcome, and also Persis' thought that we shouldn't, try too hard to predict what's going to happen, because, hopefully it won't be as bad. But I do think one of the most important things to remember about this case is that it's not like everything will be okay if we have a good outcome in Relentless and Loper Bright. I wish I could tell you it would, but in fact, things are not going to be okay regardless of what happens in this case. And I encourage folks to think about this as an example of a broader trend rather than one case whose outcome is going to make the difference. Because regardless of what the court decides in Relentless and Loper Bright, this 6-3 MAGA majority is going to continue using their power to substitute their policy preferences for those of agency experts, political leaders, and voters on administrative law issues in every area of public policy and beyond, until Congress expands and rebalances the Supreme Court. And if they don't do that, this is going to continue for, I'm not exaggerating here, the rest of our lives. So that is the situation we face. And I would like to give you a less grim note, but I'm giving you what I actually believe here. We need to take action, and there's a lot that needs to be done.
So Persis, I will ask you, if the court overrules or substantially narrows Chevron, what is it that we can do?
So, I mean, I guess my answer to this is, I don't know that. Either way, I think we should do these things, right? And I think it comes down to organizing. I think folks need to organize and, people need to pay attention. But, the courts are vesting power in themselves to make all of the decisions. We need to demand reforms. We need to demand, Supreme Court reforms. And we need to also, look at the district and appellate levels as well. I think we can't ignore the local level. And I think especially in these contexts, because that's where, like we think about these really big cases and they are incredibly important and they are, very rights determining, but we have thousands of cases every day on lower court levels that are also making just as important decisions in everyday people's lives. And I do think, at some level, we're going to see the Supreme Court, the Fifth Circuit's going to make a determination and the Supreme Court's just going to decide not to take it up. And then we're just all going to be stuck with what happens at the Fifth Circuit or, in the other cases. So people need to organize. They need to demand better from all of our federal courts. And I think we also need to be organizing on the local level too, right? Like we have ceded a lot of control to state level governments. And people need to be more aware of what's happening and taking back their state and local governments as well. For those of us who do policy work, I do think that there needs to be a real conversation in a post-Chevron world about like how do we empower our agencies to continue to do the work, because the work that they do is so vitally important that I think we cannot just say like, well, Chevron's gone. I guess there goes our administrative state. I suppose we aren't going to protect consumers anymore from big banks and like try to keep clean water. So I think what we just need to do is, organizing on all the different levels, but thinking about how we can continue to empower our federal agencies, how we can reform our courts, and then how can we take back our state governments. Just the small things.
Doug and Paul, anything you'd like to add?
So I think that there have been great big picture points that have been made. I'd like to just raise a much more narrow, small bore thing, which I think would really matter. It used to be the rule in America that a federal district court couldn't issue a nationwide injunction involving a federal agency, and that only if something was done by the DC Circuit, which was a circuit that was understood to have particular expertise in administrative law, would something be decided nationwide. And so you might find one judge someplace who would strike something down, but that wasn't the end of it. What's happening now is, Ian Millhiser, the great columnist on the Supreme Court and the legal system, keeps making jokes that the highest court in the land is the Amarillo division of the Northern District of Texas. There's really some truth to that. It's not just a joke. You basically have a couple of judges down there who feel totally empowered to throw out anything that disagrees with their worldview. And so right-wing plaintiffs who want to not have any regulation of the financial system, who want not to be able to pollute, who want to have nursing homes have no rules that govern safety for patients, just a series of things that they don't want the FDA to permit abortion medication, can go down to the Amarillo division, get a nationwide injunction, then it kicks around for a while before the Fifth Circuit acts on it. So, you literally had, this one federal district judge running our foreign policy with Mexico. He's just decided, I don't really like the way the administration is handling foreign policy of Mexico. I think that myself as the U.S. district judge in Amarillo, this really should be me rather than the Department of State and the INS and so forth. So I'm going to take it all over. That's crazy. The last time there was an opportunity to have a bill around this, where I had several conversations with people who are involved in this area, and several people were like, well, we need to be able to go to court in San Francisco to challenge the Trump administration and so forth. I think it was a short-sighted decision. Letting a single federal judge write nationwide policy for administrative agencies has turned out to be a terrible idea. And I really hope that gets changed over time. It's crazy to have a single person who's got some elements of zealotry running the whole country.
So I totally agree with Persis and Paul, and I want to give folks three specific things that we are trying to accomplish and that we would love everyone's help with to address the issues we've been talking about. Not exclusive, because we need to vote, we need to organize around every branch and level and institution of government. All of that is very important. In this specific scenario where we're talking about what the courts are doing that is so dangerous, three asks of you all and of our political leaders. One is we need Congress to expand and rebalance the Supreme Court via the Judiciary Act, a simple one-line bill. Congress does control the number of justices on the court. They have changed that number 7 times before. They have the power to do this, and you should call your members of Congress and tell them to pass that bill, the Judiciary Act, to expand the court. That's number one. Number two is, at the moment, the highest court in the land operates with the lowest ethical standards, and that is untenable, and it is part of the problem. And so we also need to tell our members of Congress to pass the Supreme Court Ethics, Recusal, and Transparency Act. That's number two. And number three is we need our senators to ensure that they are filling every vacancy on the federal bench. Remember, all these judges serve for life and have incredible power, as Paul was just laying out, even district judges all over the country. There are nearly 100 vacancies on the federal bench right now, and we need to fill every single one of those judgeships with pro-democracy nominees. President Biden is doing an incredible job picking these folks. I'm going to say better than any other president in American history in terms of who President Biden is picking for judgeships. We need to get them confirmed. We need to fill every vacancy, and we cannot allow these vacancies to remain open for a potential different president to fill next year, which is a big problem that happened when a lot of vacancies were left open at the end of the Obama administration. So we need to tell our political leaders three things: pass the Judiciary Act to expand and rebalance the Supreme Court, pass the Supreme Court Ethics, Recusal, and Transparency Act so our nation's highest court does not operate with the lowest ethical standards, and fill every judicial vacancy on the federal bench with President Biden's pro-democracy nominees.
I want to lift up one of the other solutions that I've heard if Chevron were to be overturned, and that is that Congress could codify Chevron. Whether that will happen given our current Congress, it remains to be seen. But I think even in yesterday's oral arguments, we already heard that doing so might not withstand constitutional scrutiny given this court. Paul, what are your thoughts about that?
Well, I think that the same arguments that they're making under the Administrative Procedure Act, they're also making under Article 3. And so I worry that this court won't make it possible for the Congress to enact Chevron, because if the theory is that the Administrative Procedure Act says that courts get to decide the law, but having some sort of presumption means that that's no longer true, it seems like the same kind of language as in Article 3. I think that there's some value in pushing it and trying to get it up there, and I think that to the extent that you have some of the justices up there talking about freedom and democracy and so forth, for the Congress to explicitly pass something and then to find a way to turn it, to strike it down, I think makes it harder and harder for them to claim that they are paying attention to what the Democratic elected leaders are. But I'm not super optimistic that that will work. Again, I would love to be wrong about this.
All right, we have just a few minutes left, so I will do just one last round of last words. Doug, we'll start with you.
Thank you, Beth, and thank you to Persis and Paul, to Demand Justice, and everyone for coming. I think the big picture here is it's so important to keep in mind that this is bigger than any one case. It's bigger than any one policy issue. It's bigger than any one agency, bigger than any one law. And even to the idea of codifying Chevron, which is a good idea, and else my organization, the League of Conservation Voters, we support a bill to do that. I think that even if we were able to do things like that, no matter what else we are able to do, the 6 justices who dominate our Supreme Court are bad faith actors, and they will continue using their power to impose their policy preferences on the nation for as long as they have the majority on that court. And so there are lots of other things we need to do to shore up our democracy and to fight on every policy issue at every level of government and in every branch. But one thing we cannot get past is that we cannot let these people keep their Supreme Court majority. And if Congress does not expand the court, they will keep that majority for 50 years or more. Right.
And Persis, I'll turn to you.
So thank you Thank you so much for having me. This has been a fun discussion, and I always love talking with Paul and Doug. Yeah, I mean, I think one of the things I really want to highlight is how this is a threat to multicultural democracy, and the things that are being overturned here, big picture, are things that the American people really do support. Americans do, they support, our specialty is, student debt. The vast majority of Americans do support debt cancellation. They support environmental regulation. They support consumer financial regulation. So this is a threat to democracy, and it is a threat to what the American public really wants. And so I think the way that they've been able to get away with this is by people not paying attention and not connecting the dots. And so I think it's important to have conversations like this where we can connect the dots as to like, why is it so important for us to care about what's happening in a fisheries case, and what is really the strategy behind it. And so I think, my biggest concern is like that this is multicultural democracy, that this is subverting what the American public actually wants. And so making sure that people understand the stakes of what is really happening here. So thank you so much for this conversation.
So I totally agree with what Persis just said. I think that tons of Americans believe we need to regulate pollution to protect the climate. It's really important that our drugs are safe. Things like seatbelts and airbags are good. There's a series of things that there's broad, widespread support for, and there is not a widespread recognition from a ton of Americans about the role that the Supreme Court plays in undermining these things. And for decades, if you looked at exit polls or just general polling, the Supreme Court was more important to voters on the right side, who are from the right end of the political spectrum. And voters on the left of the political spectrum, a much smaller number of people would list it in their top 5 concerns and this sort of thing. And it was something, and I think a lot of that was driven by the politics around sort of anti-choice, but it's something where there is not a widespread recognition from many, many tens of millions of Americans that having a court that is got the kinds of policy preferences this court does, and a total lack of humility that they have, where they're really willing to aggrandize power to themselves, has enormous implications for our lives. And I think in the coming years, you're going to see more and more Americans who are going to start to really understand that climate change is dramatically shifting their life, and it's going to be something that desperately needs to be dealt with. How many of those people are going to realize that having a certain kind of Supreme Court justice makes it harder and harder to do anything about that? So I think that this kind of discussion, as Persis says, connecting the dots, where Doug lays out this broad explanation of where the power grab is coming from, is so important, because I think tons of Americans don't understand what's really happening here. So I'm super grateful to be a part of this program. Thank you.
Well, I want to thank our panelists again for sharing their knowledge and expertise on this important topic. And thank you to everyone for joining us for this educational roundtable.